There are some trademark cases where the opportunity for puns is simply too good to ignore, and a recent full federal court decision involving Brown Nose Day and Red Nose Day is one of them. It's a real case. The court had to decide whether Brown Nose Day was deceptively similar to earlier Red Nose Day trademarks for charitable fundraising services. At first sniff, you might think the answer is obvious. Both marks contain a colour followed by Nose Day. They relate to the same type of service, and Red Nose Day is a name many Australians will immediately recognise. But trademark law doesn't always follow its nose in quite the way you would expect. In this case, the court concluded that Brown Nose Day and Red Nose Day were not deceptively similar. The phrase brown nose created a distinct meaning that was strong enough to separate the two marks. But the case is about more than just two colourful noses. It also examines a relatively unusual power that allows the Registrar of Trade Marks to revoke a trademark after it has already been registered. So, today we are looking at deceptive similarity, imperfect recollection, the importance of considering a trademark as a whole, and whether a registered trademark can suddenly find itself wiped from the register. Welcome back to Elise Explains IP. I'm Elise Dijkstra, and on this podcast, we look at intellectual property issues that affect businesses in the real world, what the law says, where businesses commonly run into trouble, and what you can do to protect what you are building. Today's case is Registrar of Trade Marks and National Cancer Foundation Limited, a 2026 decision of the full federal court. And I promise I will try not to make every single bad nose related pun, although IP nerds and lawyers in general love a good pun. I make no promises about good puns. The National Cancer Foundation was established in 2013. It raises funds to support cancer prevention and treatment. In April 2020, the foundation decided to pursue a brown nose theme for bowel cancer fundraising and awareness. The idea was deliberately attention-grabbing. The campaign used a combination of humour, shock, and discomfort to start conversations about a very serious health issue that people may otherwise avoid discussing. That's an important piece of context. The name was not chosen simply because brown was another colour that could be placed in front of the words Nose Day. The phrase brown nose has its own meaning, and while also providing a provocative connection to the campaign's focus on bowel cancer. On 7 May 2020, the National Cancer Foundation applied to register Brown Nose Day as a trademark for charitable fundraising services. During examination, IP Australia identified several earlier trademarks owned by Red Nose Limited. These included Red Nose Day and a series of marks comprising Nose Day together with different colours, including the aforementioned Red Nose Day, White Nose Day, Black Nose Day, Blue Nose Day, Yellow Nose Day, and Green Nose Day. So the examiner didn't miss the earlier registrations. They were identified, considered, and compared with the Brown Nose Day application. The examiner concluded that the trademarks were sufficiently different. The Brown Nose Day application was accepted, advertised, and ultimately registered in December 2020. No opposition was pursued during the formal opposition period. At that point, the National Cancer Foundation had a registered trademark, and a registered trademark is not simply a certificate to frame and put up on the wall. Under the Trademarks Act, it is personal property. It gives the owner statutory rights that can be used, licensed, assigned, and enforced. You would therefore expect a business or charity to be able to rely upon that registration. But this registration was about to receive a rather unwelcome follow-up examination. In October 2021, Red Nose Limited wrote to the registrar and requested that the Brown Nose Day registration be revoked. The following month, the Deputy Registrar notified the National Cancer Foundation that the registrar proposed to revoke the registration. The new view within IP Australia was that Brown Nose Day was substantially identical with, or deceptively similar to the earlier Red Nose Day marks. On that basis, it was said that an objection should have been raised when the application was first filed and originally examined. The National Cancer Foundation asked IP Australia to please explain the reasoning behind this change of position and to provide the documents that had been relied upon. But it ultimately emerged that there were no documents recording the reasoning process beyond the notice itself. After a hearing, the delegate of the registrar revoked the Brown Nose Day registration in February 2023. So the registration had first passed examination, had been open for opposition, had proceeded to registration, and then was revoked because a different decision maker took a different view. That's quite a journey for one knows. The National Cancer Foundation appealed to the federal court. In 2025, a single judge allowed the appeal and restored the registration. The registrar then appealed to the full federal court, which delivered its decision just recently in July 2026. So, how can a registered trademark be revoked? Before we get into the comparison between the marks, we need to look briefly at Section 84A of the Trademarks Act. This provision gives the registrar a limited power to revoke a trademark after it has been registered. Before exercising that power, however, the registrar must be satisfied of two things. First, that the trademark should not have been registered, taking into account all the circumstances that existed at the time of registration. Secondly, that it is reasonable to revoke the registration, taking into account all the circumstances. These two requirements are cumulative. Both must be satisfied. There is also an important time limit. The registrar must notify the registered owner of the proposed revocation within 12 months after registration. So it's not a general power to reconsider registrations whenever someone inside IP Australia has a change of heart or a change of nose. Nor is it limited to obvious administrative mistakes, such as overlooking an earlier trademark entirely. The legislation expressly allows the registrar to consider errors of judgment. The single judge had approached errors as existing on a continuum. At one end might be a clear mistake or oversight. At the other might be a finely balanced evaluative question on which reasonable people could disagree. The primary judge considered that a mere difference of opinion about deceptive similarity would not ordinarily be enough to establish that the mark should not have been registered. The full court disagreed with that part of the reasoning. It said that legally, the question of deceptive similarity has one correct answer. A comparison may be difficult. It may be finely balanced. Reasonable minds may disagree, but the Act does not provide a range of equally correct answers. A mark is either deceptively similar or it is not. If the mark was deceptively similar to an earlier registration and no exception applied, it should have been rejected. Its registration was therefore an error, even if the original examiner's conclusion was understandable. However, the circumstances of that error may still be relevant at the second stage, whether it is reasonable to revoke the registration. That distinction matters. The first question is, was the registration legally wrong? The second is, considering everything that has happened, is revocation reasonable? The registrar cannot ignore an error simply because it was understandable, but the registrar can consider the nature of the error, the owner's reliance upon the registration, any use of the mark, related legal proceedings, and other relevant circumstances when deciding whether revocation is reasonable. In other words, the first requirement asks whether the registration passes the legal smell test. The second asks what should practically be done about it. And that brings us to the central question. Was Brown Nose Day deceptively similar to the earlier Red Nose Day marks? Deceptive similarity does not require proof that consumers have actually been confused. This test asks whether there is a real and tangible risk that ordinary consumers might wonder whether the services offered under the two marks come from the same source or from businesses that are somehow connected. The threshold for confusion is not particularly high. The court does not place the marks neatly beside each other and invite consumers to play spot the difference. Instead, the comparison allows for imperfect recollection. Imagine someone who has encountered the earlier mark but does not have it directly in front of them. Would that person, on later encountering the new mark, wonder whether the two are connected? The marks must also be considered as a whole. You cannot simply chop them into pieces, highlight the shared words, and declare the case over. That point became crucial here. The registrar argued that the earlier marks established a highly distinctive pattern, a colour, followed by Nose Day. On that approach, Brown Nose Day could appear to be another campaign in the same family, a brown version of Red Nose Day. That is sometimes described as contextual confusion. A consumer may not believe that the two marks are identical, but might think that the second is a variation, extension, or a related brand. There was certainly some force in that argument. The services were the same. The words Nose Day appear in both marks, and the earlier registrations included multiple colour combinations combined with the words Nose Day. But the court concluded that focusing on the pattern risked pulling Brown Nose Day apart in an artificial way. The words brown nose form a familiar expression with their own distinct meaning. To brown nose someone, in case you're not already aware, is to flatter them or to curry favour with them, usually at a rather excessive pace. That meaning changes the overall expression created by the mark. Consumers were unlikely to read the name as brown plus nose day. They were more likely to understand brown nose as a complete phrase, followed by day. By comparison, red nose has its own distinct connotation, commonly associated with clowns and comedy. The full court agreed with the primary judge that these different meanings pointed away from a connection between the marks. Perhaps appropriately, neither mark was accused of brown-nosing each other. There was also expert evidence about the role that colour plays in charitable fundraising campaigns. The evidence suggests that Australian consumers are accustomed to distinguishing between different awareness campaigns by reference to colour and other prominent features. We regularly encounter campaign names that combine a colour, an object, or a cause with a period of time such as a day, week, or month. The court accepted that day therefore carried relatively little weight in distinguishing one charitable campaign from another. Colour, on the other hand, could be an important differentiator. The court also noted that charitable donations tend to involve a degree of consumer consideration and discernment. People may pay closer attention to an organisation they are supporting than they would to a small routine purchase. That does not mean that charities receive some special exemption from the usual deceptive similarity test, nor does it mean confusion must persist all the way from to the point of donation. But the characteristics of a likely audience and the nature of the service remain part of the overall assessment. Ultimately, the court considered the matter finely balanced, but concluded that Brown Nose Day was not deceptively similar to the earlier marks. The distinct and somewhat confronting meaning of brown nose carried significant weight. Consumers were unlikely to interpret it as simply another colour in a Nose Day series. Because there was no deceptive similarity, therefore, the original registration was not an error. That meant that the first requirement under Section 84A was not satisfied, and the registrar's power to revoke the registration was never enlivened. The registration has survived, and the registrar's appeal was dismissed. Brown Nose Day, you might say, came out a nose in front. But what about the reputation of Red Nose Day? One aspect of this case that may surprise businesses is that when deciding whether the marks themselves were deceptively similar, the court could not simply rely on the fame or reputation of Red Nose Day. The statutory comparison is focused on the marks as registered and the services covered by those registrations. It is not a broad inquiry into everything consumers know about the existing brand. This can feel somewhat artificial. In the real world, reputation influences how consumers interpret a name. A very well-known brand may be far more likely to spring to mind than one that exists only on the trademarks register. But trademark law deals with reputation through particular other provisions and causes of action. Reputation cannot automatically be imported into every deceptive similarity comparison. This is one reason trademark disputes can produce results that initially seem counterintuitive. There is often more than one legal question available. Are the trademarks deceptively similar? Perhaps. Does the later mark falsely suggest a connection? Maybe. Has the earlier owner developed a reputation that gives rise to broader protection? Could the conduct be misleading or deceptive? Those questions may overlap, but they are not interchangeable. Choosing the right ground and producing the evidence needed for that ground can determine the outcome of the legal proceedings. So, what are some practical lessons? The first one is to assess the whole mark. Shared words do matter, particularly where they are distinctive, but they do not automatically decide the results. Meaning, sound, appearance, and overall impression all contribute to the comparison. A word that forms part of a familiar expression may change the character of the entire mark. And that's exactly what happened here with brown nose. For business owners, this means a basic word-for-word comparison is not enough when assessing a proposed brand. Two names can look different on a spreadsheet, but create a similar overall impression. Conversely, names sharing several elements may still convey a different idea and a different impression. The question is not just how many words do these marks have in common? It is, what will someone with an imperfect memory take away from each mark? Practical lesson number 2, do not confuse registration with permanent certainty. The second lesson is that registration is enormously valuable, but there are some limited circumstances in which it can be challenged, revoked, or cancelled. The Registrar's Section 84A power is time limited, but it is broader than a power to correct typographical mistakes or obvious oversights. An error of judgment can be enough to satisfy the first part of the test. That makes the examination stage important, but it also reinforces why businesses should carry out their own clearance work before adopting and investing in a brand. Acceptance by IP Australia is not a commercial guarantee that no one will object, that the mark will proceed to registration, and that you won't later be subject of a non-use application. Even after registration, an earlier owner may seek revocation within the statutory window or pursue some other legal options. A proper trademark search should therefore look beyond exact matches. It should consider similar words, sounds, concepts, structures, and the goods or services covered by earlier registrations. You want to sniff out the problem before you order your signage, launch the campaign, and build an entire brand around a name. Practical lesson 3, monitor new applications. There is also a lesson here for owners of existing trademarks. Red Nose Limited's marks were identified during the examination, but the Brown Nose Day application was accepted and advertised. No opposition was pursued at that stage. Once the mark had proceeded to registration, the available pathways became much more complicated. Trademark monitoring gives owners an opportunity to identify potentially conflicting applications during the opposition period, before they become registrations. That does not mean that every remotely similar application should be opposed. Some marks can coexist. Sometimes a negotiated limitation, consent arrangement, or practical agreement is more proportionate. But if you do not know what is being filed, you lose the opportunity to make that decision at the most useful time. A registration is not a set and forget asset. Practical lesson 4. Document the reasoning. Finally, this case is a reminder of the importance of a clear record when valuable rights are being created or removed. The National Cancer Foundation asked for the reasonings, the documents, explaining why IP Australia had changed its position, but there were no recorded reasoning beyond the notice of intention to revoke. The ultimate appeal was determined on its legal merits, but from a governance and fairness perspective, unexplained changes of view create uncertainty and cost. The same lesson applies within a business. If you choose a name despite an identified risk, record the advice received and the commercial reasoning behind the decision. If ownership is transferred between entities, make sure you document it properly. If a brand is licensed, record the terms and maintain appropriate control over its use. If you allow another party to use a similar mark, be clear about what has been agreed in a letter of consent or an agreement. Good records may not make a dispute disappear, but they can prevent a difficult situation becoming even messier. So, what should we take from the Battle of the Noses? Brown Nose Day and Red Nose Day were held not to be deceptively similar because each mark created a different overall impression. The familiar expression brown nose gave the later mark a distinct meaning. Consumers were unlikely to see it as merely another coloured variation of Red Nose Day. The case also confirms that the registrar's post-registration revocation power can extend to errors of judgment. A finely balanced mistake is still an error. However, identifying an error and deciding whether it is reasonable to revoke a registration are two separate questions. For businesses, the practical message is simple. Choose a trademark that creates its own clear identity. Search it properly before you commit to it. Monitor the register after you obtain protection, and remember that the legal comparison concerns the overall impression of a mark, not simply the number of words it shares with something that may have come before. Sometimes a small change will not be enough to dispel that similar impression and avoid confusion. But sometimes one carefully chosen word completely changes the scent of the mark. If you are developing a new brand, preparing to file a trademark application, or concerned about a similar name appearing in the marketplace, this is exactly the sort of issue worth examining before it becomes an expensive dispute. You can book a strategy call with me through my website at elisedikstra.com. Thanks for listening to Elise Explains IP. And if you've enjoyed this episode, please follow the podcast and share it with someone who appreciates a trademark decision containing just the right amount of legal substance and just a little bit of brown nosing. I'll see you next time. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.